This Week in Law is up next with Emily Michiko-Morris and Tyler Ochoa. We're going to talk about tech policy in U.S. politics, specifically in the Republican debates, Katy Perry's copyrighted dress, pre-1972 sound recordings, patentability, and much more next on This Week in Law.
Netcasts you love.
From people you trust.
This is TWiL.
Bandwidth for This Week in Law is provided by CacheFly at CacheFly.com.
This is TWiL, This Week in Law with Denise Howell and Sarah Pearson. Episode 314, recorded August 7th, 2015. Con with EULA. This episode of This Week in Law is brought to you by Casper, an online retailer of premium mattresses for a fraction of the price, because everyone deserves a great night's sleep. Get $50 off any mattress purchase by visiting casper.com/TWiL and enter promo code TWiL. And by FreshBooks, the super simple cloud accounting and invoicing solution that can help your law firm and any small business save time billing and get paid faster. Try it free at freshbooks.com/TWiL. Hi, folks. I'm Denise Howell, and you're joining us for This Week in Law. I'm so excited that you're here with us this week. We've got two excellent legal scholars joining us today who I'm very happy to welcome to the show. Neither of them have joined us before, so you're in for a treat. We have Tyler T. Ochoa joining us. He is a professor at Santa Clara University School of Law, where he specializes in copyrights and rights of publicity. The little known fact or just trivia fact about Tyler is he's also a two-time Jeopardy champion, and he also was a champion on Win Ben Stein's Money. So hopefully you're going to be our winning guest contestant today. Welcome to the show, Tyler.
Thank you. Glad to be here.
Great to see you. Also joining us is Emily Michiko-Morris, who is a patent scholar and professor at Indiana University School of Law, where she teaches intellectual property, patent, and copyright. Hello, Emily.
Hello.
Very good to have you on the show. We were just talking before the show about the debates last night and who had seen what, and the fact that some tech policy issues crept into the Republican debates that took place yesterday. So we thought we would lead off the show with that, since it's always interesting when technology policy is on the national U.S. political agenda. And it actually cropped up in both the debates last night, both the primetime one and the happy hour one. So that's where we're going to start the show. It's always good to start This Week in Law during happy hour, of course, with everybody being very cautious with their driving and how they're approaching the happy hour situation. It is Friday when we record these shows. So let's start with Carly Fiorina during the happy hour debate, who took the first tech policy question of the evening, not surprisingly, given her background. The clip that we have queued up does not have the question she was asked. So I'm going to do my best here to channel moderator Megan Kelly for a moment and ask the question, and then we'll play her answer to it. She was asked, the FBI director, Corney, says that terrorists can thrive here at home because they go dark and recruit behind the cyber walls that are built by American companies like Google and Apple. Corney says this is a big problem. Rand Paul says that the government forcing these companies to bring down those walls would be a big privacy issue and a dangerous way to go on this. You've been a tech leader in this country. Which side are you on? And here's what Carly Fiorina had to say.
That it is disturbing that every time one of these homegrown terrorist attacks occurs, and as your question points out, they are occurring with far too great frequency, it turns out we had warning signals. It turns out we knew something was wrong. It turns out some dot wasn't connected. And so the first thing we have to do is make sure that everyone and every responsible agency is attuned to all of these possibilities and symptoms. We even had warnings about the Boston Marathon bombers, and yet the dots weren't connected. So we need to get on a different mindset. Secondly, I certainly support that we need to tear down cyber walls, not on a mass basis, but on a targeted basis. But let me just say that we also need to tear down the cyber walls that China is erecting, that Russia is erecting. We need to be very well aware of the fact that China and Russia are using technology to attack us, just as ISIS is using technology to recruit those who would murder American citizens. I do not believe that we need to wholesale destroy every American citizen's privacy in order to go after those that we know are suspect or are already a problem. But yes, there is more collaboration required between private sector companies and the public sector. And specifically, we know that we could have detected and repelled some of these cyber attacks if that collaboration had been permitted. A law has been sitting, languishing, sadly, on Capitol Hill and has not yet been passed. It would help.
So would you tonight call for Google and Apple to cooperate in these investigations and let the FBI in where they need to go?
I absolutely would call on them to collaborate and cooperate.
So I'll just give you my opinion to start things off. I think she did a pretty admirable job answering that question and acknowledged the competing interests at play that definitely were faced with a privacy and a Fourth Amendment issue here in accessing people's personal information without their consent. As well as the important national security considerations. I would have loved to hear her say the words due process. They would have been consistent with her position, but maybe trigger words for her Republican base. I don't know. It would have been nice to hear those words come out of her mouth. They didn't, but I think she at least touched on the fact that that's an issue. Tyler, what did you think her answer to this question could have added or subtracted?
Well, the thing I would have liked to have heard is the word warrant, right? If you have reasonable suspicion that somebody is engaged in unlawful activity, you should be able to go to a court and get a warrant. If you've got a search warrant, then you've got a court order that says that Google or Facebook has to turn something over. And when they receive that sort of thing, then they're protected because a court has said that you need, somebody's looked at it and said, yes, we've balanced the interests here and you need to turn that over.
Emily, any reactions to Carly Fiorina's take on cybersecurity versus data security?
Well, I have to say I agree with both you and Tyler. It would have been nice to hear a little bit more about on what grounds Google or other companies like that would be required to cooperate with law enforcement. And it's interesting that Ms. Fiorina mentioned China, because one of the reasons that Google no longer operates in China is because it refused to give the Chinese government the kind of access to its users and its users' databases that the Chinese government wanted for its own purposes. So to say that the United States government should have similar access to Google's databases or what goes on behind Google's cyber walls is a little ironic, maybe. And it also occurred to me that it almost sounds like she's talking about imposing a duty on Google that's very similar to what we have with copyright infringement, where for a lot of these service providers, they have an affirmative duty to monitor or at least to remove infringing content when they're given notice. And so it seems like she's setting a higher standard for Google than she is, than would seem appropriate under the Fourth Amendment.
Yeah, excellent points, both of you. We're about to hear the word warrant. The second moment that tech policy crept into the debates involved an exchange between Chris Christie and Rand Paul in the second debate that took place yesterday. And let's play that through in its entirety.
Talk a bit about terror and national security. Governor Christie, you have said that Senator Paul's opposition to the NSA's collection of phone records has made the United States weaker and more vulnerable, even going so far as to say that he should be called before Congress to answer for it if we should be hit by another terrorist attack. Do you really believe you can assign blame to Senator Paul just for opposing the bulk collection of people's phone records in the event of a terrorist attack?
Yes, I do. And I'll tell you why. Because I'm the only person on this stage who's actually filed applications under the Patriot Act, who have gone before the the Foreign Intelligence Service Court, who has prosecuted and investigated and jailed terrorists in this country after September 11th. I was appointed U.S. Attorney by President Bush on September 10th, 2001, and the world changed enormously the next day. And it happened in my state. This is not theoretical to me. I went to the funerals. We lost friends of ours in the Trade Center that day. My own wife was 2 blocks from the Trade Center that day at her office, having gone through it that morning. When you actually have to be responsible for doing this, you can do it, and we did it for 7 years in my office, respecting civil liberties and protecting the homeland. And I will make no apologies ever for protecting the lives and the safety of the American people. We have to give more tools to our folks to be able to do that, not fewer, and then trust those people and oversee them to do it the right way. As president, that is exactly what I'll do.
Megan, may I respond? May I respond?
Go ahead, sir.
I want to collect more records from terrorists, but less records from innocent Americans. The Fourth Amendment was what we fought the revolution over. John Adams said it was the spark that led to our war for independence. And I'm proud of standing for the Bill of Rights, and I will continue to stand for the Bill of Rights.
And Megan, that's a completely ridiculous answer. I want to collect more records from terrorists, but less records from other people. How are you supposed to know, Megan?
Use the Fourth Amendment.
How are you supposed
Use
to?
The Fourth
I'll
Amendment.
tell you how you
get a warrant.
Let me tell you something.
Get a judge to sign a warrant.
Senator.
Go ahead, wait, Governor Christie, make your point.
Listen, Senator, when you're sitting in a subcommittee just blowing hot air about this, you can say things like that. When you're responsible for protecting the lives of the American people, then what you need to do is to make sure that you use the system the way it's supposed to work.
Here's the problem, Governor. You fundamentally misunderstand the Bill of Rights. Every time you did a case, you got a warrant from a judge. I'm talking about searches without warrants, indiscriminately of all Americans' records, and that's what I fought to end. I don't trust President Obama with our records. I know you gave him a big hug, and if you want to give him a big hug again, go right ahead.
Go ahead, Governor.
And Senator Paul, the hugs that I remember are the hugs that I gave to the families who lost their people on September 11th. Those are the hugs I remember, and those had nothing to do with politics, unlike what you're doing by cutting speeches on the floor of the Senate, then putting them on the internet within a half an hour to raise money for your campaign, and while still putting our country at risk.
All right, we're going to cut it off there. We have plenty more.
Yeah, that was a good place to cut it off. So hugs and warrants aside, the part of that exchange that leapt out at me was Chris Christie, the former U.S. attorney, claiming that it's impossible to collect data only from the people under suspicion and being investigated, and that we need to do this bulk metadata collection in order that is all available for searching when someone comes under suspicion. Tyler, what do you think about that approach?
Well, so the law that was passed recently says that the government isn't going to be collecting that bulk data anymore as long as the phone companies agree that they will store it for a certain period of time so that when you get a warrant, you can go back and look through it and find that data. The phone companies need to collect that data for business purposes for a limited period of time. The law specifies how long that they need to keep it. I don't remember what the exact period is, but that strikes me as a reasonable compromise here.
All right. Anything else about this exchange that stood out for you as far as the role of tech policy in presidential politics?
I I doubt most people are going to be casting their vote based on the role of tech policy. So
right.
I'm not sure that ultimately that's going to make a big difference in the primary or the election.
But what's interesting to me is here very early on in these August debates, the issue did come up in both sets of debates. I think this privacy question is very much on people's minds, and I won't be surprised, and I certainly hope that that discussion continues and that the candidates continue to be probed. Poor Carly Fiorina will probably continue to be the one fielding most of those questions, given her background, and Rand Paul too, given his filibuster. But it's nice to see the discussion taking place alongside all of the other issues that perhaps are more what people are prone to vote on, as you point out, Tyler. Emily, what do you think?
I have to agree with Tyler. I really don't see voters worrying much about tech policy. But of course, what do we mean by tech policy? Technology affects every aspect of our lives. It very much affects privacy. And I think part of the problem with the law is that it's always behind the technological developments. And so we're constantly running to try to catch up with the latest technologies and what they mean in terms of in privacy. Do we have a reasonable expectation of privacy with regard to data? Or is that something that we're doing in a public forum, and therefore it's publicly available and it's free for law enforcement officials to take notice of? And we're constantly trying to catch up with that. And I think even as a people, we're trying constantly to catch up and decide what we think is privacy and what we think is public. So it's a difficult issue, and I don't think people really realize how much the technology really plays a role.
All right, well, we're going to put our first MCLE passphrase into this show for folks who are lawyers and listen for continuing legal education credit, or for folks in other professions who listen to the show for professional credit in other fields. We put a couple of instances of secret voids into the show that you can show to any oversight body that wants to confirm that you have watched or listened. So our first phrase is going to be hugs and warrants. Write that down somewhere, and we'll put another phrase into the show a little bit later. I think now would be a good time, too, to stop and thank our first sponsor for this episode of This Week in Law, which is Casper. Casper, if you are not already aware, is an online retailer of premium mattresses for a fraction of the cost. And they've been a sponsor here on the network for several months now, and I wish that they had been a sponsor for a longer time. And I'm so glad to be able to perhaps help you avoid what I went through, which is I recently needed to replace our mattress, and it's a terrible process in the traditional way. The mattress industry was definitely waiting for Casper to come along and revolutionize it, and it's certainly done so. And having just gone through the process the old-fashioned way, and as the follow-up to that, now that I know about Casper, even though I'm not sleeping on a Casper mattress, my child is. I said on a show a few episodes ago when Casper was a sponsor that you should try it out on the bunk beds in your kids' room. And that's exactly what I did because, first of all, the cost is amazing. And I knew that I could return them in a heartbeat. The delivery process and return process is very streamlined with Casper. So I knew it was a no-risk situation and I could try these mattresses out. And now that we've got them, I so wish that I had done it on my main bed too. But now, having made the investment in a new mattress the conventional way, I'm kind of out of luck there. So hopefully you will be able to try out Casper yourself and see if it's the right mattress for you. I think it would have been the right mattress for me to sleep on long-term. My son certainly has been enjoying his. I'll tell you why I like his so much. It's a very unique kind of mattress. You know, these memory foam mattresses are all the rage these days. They don't work well for me. We live in a place that gets pretty warm and we don't have air conditioning, and the memory foam ones are just too warm. You sort of, speaking of hugs, you sort of sink into them and they sort of hug you all night and it's a little bit too warm. But these Casper mattresses have a bit more spring to them. They're still sinky in a little bit of a way, but in a really comfortable way. They're very supportive too. They cut the cost of dealing with resellers and showrooms. You don't have to go lay down on mattresses in showrooms, which is a little bit of a strange scenario to find yourself in. They engineer their mattresses obsessively. They use two technologies, both latex and memory foam. They bring them together for better nights and brighter days. It's a really, really comfortable mattress. It has just the right sink and bounce, and it provides long-lasting comfort and support. It's super easy to buy online, and as I mentioned, it's completely risk-free. You need to try it out, a mattress. You don't know, different people sleep different ways. You have to try one out and sleep on it to see if it works for you. So Casper has really decided to make delivery free and painless. It gives you 100 days to try out the mattress, so you can really try it out in your home and make sure it works for you, hopefully over a couple of different seasons. Now in the summertime, I think is a great time to try out a new mattress, because it tends to be when you need to see whether it's going to be too warm for you or not. Did you know that statistically lying on a bed in a showroom has no correlation whatsoever to whether it's the right bed for you? So you really need to try it out at home. And you can feel good about the fact that Casper's mattresses are made in the USA. So get a Casper mattress. They're $500 for a twin or $950 for a king-size mattress. I challenge you to go out and find any other decent king-size mattress for even close to that price. It's really an outstanding price. And you can save an additional $50 as one of our audience members by going to casper.com/TWiL and entering the promo code TWiL. That's casper.com/TWiL and entering TWiL. Thanks, Casper, for making mattresses better and in a new and revolutionary way. All right, let's move on to copyrights. Tyler, the really interesting case in California that you wrote up over on the Technology and Marketing Law blog has to do with the first sale doctrine and the fact that California has its own state law that tries to countermand the first sale doctrine a bit. Stepping back for a moment to explain what the first sale doctrine is. What it is, for folks not familiar with it, we talk about it quite a bit on the show, is the fact that once you've bought something that is subject to copyright, you can resell it again once. And this is leaving aside the whole can of worms around digital things and whether you've bought them or not. Let's stick to the physical realm for a moment. And specifically, this case that we're about to discuss involved a piece of art. What generally happens is you can buy it, hold it, it can appreciate in value, you can resell it, and you won't owe the original rights holder, the artist, any additional money that may be attributable. You won't owe them anything. You won't owe them any royalties at all when you resell it, whether it's appreciated in value a lot or not at all. But in California, we have a slightly different law. It's called the Resale Royalty Statute, California Civil Code Section 986. And it attempted and still attempts to make you pay a 5% royalty when you resell a work of art, a copyrighted work that was generated within, or the sale takes place within California, or the seller resides in California. And it attempted to apply that 5% royalty requirement to sales taking place elsewhere. Tyler, can you let us know what happened with this case and what part of that law still survives now?
Sure. This law has been on the books for a number of years now, but it's generally not been enforced. But the idea is that if you resell a work of art and the price has gone up, so there's been an appreciation, you're making a profit on the resale, then you should have to pay a portion of those proceeds to the artist or to the artist's estate for a period of 50 years after the artist has died. So in this case, we had the estates of two artists, the estate of Robert Graham and the Sam Francis Foundation, and each of them sued one of the New York auction houses, Sotheby's and Christie's, when one of the works of arts of those artists was resold, and the person who sold it resided in California, because that's what the statute provides, that the sale takes place in California, or the seller resides in California, then the seller has to set aside 5% of the proceeds to pay for the artist. And the auction houses in New York, the allegation was that the auction houses in New York were acting as the agents for the seller, and under the law, they had the obligation to collect the 5% on behalf of the seller and remit it to the artist. So the estates of these artists sued the auction houses in New York, said, you need to collect the 5% on our behalf. And the auction houses in New York challenged the law and said that that's unconstitutional under what's known as the Dormant Commerce Clause. The Commerce Clause of the Constitution says that Congress has the power to regulate interstate commerce, commerce between the states, commerce between one state and a foreign nation, or commerce between the states. And the Supreme Court has drawn from that a negative implication, the Dormant Commerce Clause, that states cannot regulate interstate commerce. States cannot burden interstate commerce in a way that would prevent interstate commerce from going on. So states can regulate within their own borders, but they can't regulate transactions that cross the border of a state. And so what the auction houses said in this case was these transactions are taking place in New York, and California doesn't have any power to regulate what goes on in New York. And what the artist estate responded was, well, but the seller resides in California. All we're trying to regulate is money that's coming into California from somewhere else. All we're saying is that some of that money has to be set aside from the artist. And the U.S. Court of Appeals for the Ninth Circuit agreed with the auction houses and said that you cannot regulate this transaction. This transaction takes place outside the borders of the state. So even though the person who is the seller resides in California, the transaction, the painting is in New York at the auction house. The transaction is between the auction house and some buyer in some other place. When the transaction takes place outside the state, California can't regulate it, and therefore this law is unconstitutional as applied to sales that take place outside of California. Unlike the district court, however, the Court of Appeals said this law can still be applied when the sale takes place inside California. So we can sever the two portions of the statute. We can ignore the portion of the statute that says if the seller resides in California, that's unconstitutional when it's applied to sales that take place outside California. But if the sale takes place in California, the law can still be applied as far as the Commerce Clause is concerned. Now, there's another issue in the case, which is whether or not that law conflicts with the Federal Copyright Act. They've sent the case back to the district court. The district court's going to decide that second issue.
So is the first sale doctrine actually codified in the Federal Copyright Act, or is it a creature of judicial precedent?
Originally, it was a creature of judicial precedent. The U.S. Supreme Court recognized it in 1908. But it is codified in the 1976 Copyright Act in 17 U.S. Code, Section 109. Section 109 says, under the first sale doctrine, that notwithstanding the exclusive right of distribution, the owner of a particular copy has the right to redistribute that copy without permission from the copyright owner. And the owner of a particular copy also has the right to publicly display that copy without the permission of the copyright owner.
So because it sounds like the federal law and this California law do clash on that issue, do you think when it goes back to the district court, the entirety of this California statute will fall by the wayside?
I think it will. There is an argument that it's not really a clash because California law doesn't prevent the owner of a work of art from selling it or redistributing it. It doesn't attempt to stop that. What it says is if you do that, then a certain amount of proceeds go back to the artist. I do think that's inconsistent with the federal legislation the way that it's written, and I do expect it to be preempted. There was a case in the Ninth Circuit under the old 1909 Act, which also had a codified version of the first sale doctrine. They said, no, we don't think this is inconsistent with the first sale doctrine. We think it supplements the first sale doctrine. But I think that case was wrongly decided. They expressly said, we're not saying anything about the 1976 Copyright Act. I do expect, if and when that issue gets back to the Ninth Circuit, that they'll say, yes, this is preempted by the Federal Copyright Act. But it's not certain.
Emily, you mentioned earlier how technology outpaces law in many instances and outpaces the way the law would operate on the way that people conduct business and their lives. And this seems like one of those kinds of circumstances that it's strange to be talking about where a sale takes place and making economic and business decisions about that in the internet era, isn't it?
It certainly is. I think the line between purely intrastate commerce and interstate commerce is certainly blurred in the modern information age. And yet one of the thoughts that I had also was that this kind of harkens back to some age-old problems. Again, the conflict between federal laws and state laws, but also one of the things I was wondering is, and maybe this is a good question for Tyler, what would happen if the California state legislature said, okay, we're going to modify the law and say it applies regardless of whether the artwork is copyrighted or applies only to artwork that is no longer copyrighted or whose copyright has been abandoned. And so it produces not only this interesting interplay between modern commerce, as you said, that is much less clear than it used to be, but also some of the same age-old problems between the states and their purview to legislate and then federal law.
Well,
what do you think about that?
The California law isn't actually conditioned on whether or not the work is copyrighted as such. It doesn't use the word copyright. It doesn't mention copyright in there. California law is limited to works of art where the artist died less than 50 years ago. And of course, all such works of art are under copyright because that was the term of copyright at the time the legislation was passed. It's since been extended federally to life of the author plus 70 years. The California law is only life of the author plus 50 years. So it does only apply to copyrighted works, but not because they specified we want to do something with copyright, just because they limited it to more recent works. And that's in accordance with neighboring rights protections, copyright protections that we see in Europe and elsewhere. Europe has resale royalty legislation where the owner of original work of art does get paid when a work is resold for a period of time during the time that the copyright is valid. One of the reasons this comes up is because copyright's a law that's written for books. And anytime you think something's kind of funny in copyright, think about how it works in the book world and then try to apply it elsewhere. And in the book world, reselling a copy of a book is no problem. Nobody has any difficulty with that because each copy of the book is the same, contains the same text, doesn't have any particular value. You know, sometimes a first edition is a little more valuable than later editions of a book. But, you know, you're not really making a lot of money reselling a copy of a book. When we're dealing with works of fine art, then the original piece of art has a status which gives its value that's far and beyond any copies of that work that might be out there. And so that's why some people think it's unfair that the artist doesn't realize any of the appreciation of the work. But when you think about works that are already in the public domain, say you own a Rembrandt in your house, does the government have any say over what you can do with that Rembrandt? And under U.S. law, the answer would be absolutely not. Joseph Sachs wrote a book called Playing Darts with a Rembrandt. And if you own a Rembrandt and you don't mind losing the millions of dollars, you can play darts with it. You can burn it in your fireplace. And the question is should the government be able to put any restraints on that, because in some sense, Rembrandt is part of our shared cultural heritage, and maybe the government should be able to say, look, if you want to play darts with it, we're not going to let you do that. You can play darts with a reproduction, but the original is something that we should try to preserve. And so you can see notions of art preservation behind, for example, Section 106 capital A in the Copyright Act, the moral rights. But again, that only applies to relatively recent works. It doesn't apply to works that are hundreds of years old. We rely currently on the goodwill of the people who own those works and their investment in it to take care of the value in those works. But that's not a surefire thing. And you could have some rich jerk who wants to buy a valuable painting just so they can burn it. And currently, there's nothing in U.S. law that would prevent that.
All right. Well, I think it's a fascinating issue. I think that if we were to go down the rat hole of digital works and one's ability to own them and then perhaps resell them, that this would just be another layer on the thorny issues involved there. But we'll save that discussion for another day. And we'll go on to another thorny issue that sort of twisted up my mind when I read about it on the Patently O blog. There, Dennis Crouch was recently blogging about copywriting one's patent. Now, this would be your patent application that we're talking about. And he reached out to you, Tyler, to figure out the legal niceties of that situation. And you pulled out a 1929 Second Circuit case that had some bearing on this issue. First of all, let's talk about, before we get into the legalities of whether you can copyright your patent application, why would someone want to do this?
Well, Emily might have some more insight into why someone might want to do that, but you may put into your patent application a flow chart or some diagrams, something that you might consider proprietary under copyright law that you don't want other people reproducing. So maybe you want to put a copyright notice on that picture or that flow chart, or even on the text of what you've written. A patent's kind of a funny thing because a patent lets you write your own exclusive right. Right? The patent says you have an exclusive right to make, use, sell, offer for sale, or import your invention, but you get to define what your invention is. And so a patent, the document that issues from the government, is actually drafted by the patent owner. Patent owner drafts an application, submits it to the government. Government decides whether it meets the standards. But if the government decides it meets the standards, then it grants your application the way that you, the applicant, wrote it. And so under copyright law, if you've written something, ordinarily, you can prevent other people from duplicating what you've written. But the whole point of a patent is to teach other people to do how you did what you did. And so patents traditionally have been reproduced and freely distributed. They're treated like other government documents that aren't subject to copyright, and anybody can copy it and use it and freely distribute it. And so the question here is, well, can I prevent somebody from copying and freely distributing my patent document by including in my patent document something that I'm claiming copyright over? And I claim copyright typically by putting a copyright notice on it, although that's not actually a legal requirement of the law anymore. And I think that violates the whole idea of what patent is about. And you should be able to freely copy patent documents, and maybe we should override copyright in this instance, but there's nothing in the copyright law that says we're going to make an exception for patents. And so it gets to be a tricky issue of public policy.
Emily, do you have any other ideas on why someone would want to copyright a patent rather than the sort of nefarious hidden agenda kind of approach that Tyler was outlining, that you have, ulterior motives?
To be honest, I can't think of any other reasons other than ulterior motives in an attempt to bootstrap copyright rights to cover what you've already had patent rights over. Copyrights, of course, last much longer than patent rights. So I can see this as an attempt to what we call evergreen a patent right once it's expired, and in particular to try to copyright those parts of the patent that would make it very difficult for others to practice your patent, practice your invention once the patent's expired. Otherwise, there really isn't a whole lot of purpose into asserting copyright rights over a patent. And even if you could, there's copyright rights would have to be very thin. Most of what is contained in a patent is very factual, so it's not copyrightable subject matter. And in fact, Tyler mentions that patents are kind of unusual in that you can draft as the rights holder what you think your patent rights should be, but they're also a little bit different from other types of intellectual property rights in that they are negotiated with the patent office right down to the format that you use. And so arguably, it's somewhat contract-like in that way, in which it's a negotiation with the patent office and really is not the fully creative work of the patent applicant. So it's an interesting concept, but it's really difficult for me to see it as anything other than an attempt to bootstrap copyright rights to cover something that's already patented. At least at first glance, it would seem that a court would come forth and say, hey, look, you already have a patent right. You can't copyright something. We've seen this in the trademark arena as well. But technically speaking, what they would be copyrighting is something slightly different than the res of what they're patenting. So what they're patenting is the inventive concept. What they're copywriting is the creativity, to the extent there is any, that goes into the patent. And so they are arguably two different pieces of subject matter. Nonetheless, I think Tyler's absolutely right that this is really an attempt to try to prolong patent rights beyond the 20-year term.
So, Tyler, if there were a way to do this to allow people to simply copyright the creative aspects of their patent and not artificially prolong their patent, would you be comfortable with it?
So, copyright has a basic principle that copyright doesn't cover ideas, processes, systems, methods of operation, concepts, principles, or discoveries. And that's codified in Section 102B of the Copyright Act. So the idea of the patent application is to teach somebody how to do your invention so that when it goes into the public domain 20 years later, people can practice the invention without any difficulty. So under traditional copyright principles, even if you've copyrighted, say, the text of a scientific article, you can't copyright the ideas that underlie that text. You can only copyright the way that you've explained it, but you can't prevent other people from using the underlying ideas. So a copyright on a patent shouldn't prevent you from practicing the invention. It should only prevent you from using the exact words of the application to explain that idea to others.
How about the designs? There is a burgeoning, and I realize this is probably a very niche audience, but it's still selling patent applications for a commercial purpose. There is a burgeoning field on Etsy of the ability to buy patent drawings as art. And they're quite attractive. And so if you go to Etsy.com and look up patent prints, you'll find quite a few of them for sale. And I'm fairly certain no royalties are being paid to the patent applicants there. And this is obviously not a huge national crisis or anything, but I just think it's funny in the context of thinking about patenting or copywriting a patent.
Well, that's certainly one reason why somebody might want to have a copyright on it if they think that this drawing is going to end up being so valuable that people are going to want to pay money for it to get a print or a T-shirt with this patent drawing on it. And maybe they want to receive a cut of those proceeds. I think that's a pretty niche market. I don't know that there's going to be a lot of money here. You know, in theory, you could separate those two things.
It's the definition of a niche market. I think you, me, and Emily might be, the sum total of the market of someone who might buy a patent print and put it on the wall. I have done so. That's why I know they exist. But it's
not just a niche market; it's a geek market.
Yeah, absolutely.
And in that instance, if you're using the drawings and the patent purely for decorative purposes, presumably that doesn't conflict as much with what Tyler noted was the public notice function of patents. That people would still be able to practice the underlying invention, they just wouldn't be able to sell the patent document itself as art. Nonetheless, I still wonder, under copyright law, you have the right as a copyright owner to prevent others from making derivatives of your copyrighted work. And so with the Lego design that you just showed us, if somebody actually makes a Lego, which is practicing the invention, presumably, is that also a derivative under copyright law? Would you thereby be able to bootstrap copyright law into preventing someone else from actually practicing your invention once the patent's expired? So I think the line drawing problem gets to be a little too difficult. And I think this is one instance in which ideally a court would say, hey, look, these are two separate areas of intellectual property. You cannot layer one on top of the other.
So there's an interesting principle of copyright law under the old 1909 Act that said if you have a copyright in a two-dimensional work of art, that does not, a two-dimensional work of art that depicts a useful article, that does not give you the exclusive right to manufacture the useful article itself. So you can copyright a drawing of an automobile, but that doesn't give you rights to prevent other people from making an automobile. And the whole purpose of that doctrine was to separate the worlds of copyright and patent. And when they drafted the 1976 Act, they said, well, we like this principle, but we don't really know how to state it properly. So what they put in the 1976 Act was a section, Section 113B, that says, with regard to drawings of useful articles, the law should be the same as it was under the old Act. And the problem is that hardly anybody is alive today who was practicing under the old Act, and this principle has kind of been forgotten. And so you do see cases in the copyright literature where someone, you know, copyrights the blueprints for a useful article like a latch or a set of tires, and then says, well, that gives me the exclusive right to make the tires. And the courts have bought into that because they've forgotten this old principle that we had under the 1909 Act that is alluded to in the 1976 Act but isn't referred to by name.
All right, moving on to other ways in which design can be derivative and trigger interesting copyright questions. Recently, Katy Perry wore a dress to the Met Gala, and it was a graffiti-oriented design by designer Moschino. Joseph Tierney is a street artist known as Rhyme, and he is suing over this dress because it used one of his tags, something called Scandal Eyes, that is well known and on a wall. And it was reproduced and put on the dress along also, and this adds an interesting element to the case, along with the artist's name and signature. So he has brought a lawsuit, and he's claiming copyright violation and also right of publicity violation for unauthorized use of his name and signature. So this has just been filed, and there's no resolution or even any kind of substantive back and forth on the legal front about it yet. But I bring it up today because it raises both the design aspect of repurposing someone's street art, which generally involves repurposing other people's art too. So it gets a bit recursive there, and also the right of publicity aspect of putting an artist's signature on something that's going to be resold commercially and his name. So, Tyler, do you have any take on this?
That strikes me as a pretty clear violation of both copyright law and right of publicity. Copyright says if you create an original work of art, you have the exclusive right to reproduce it. And this graffiti artist has created an original work of art on a wall, and it's been reproduced on a dress without his permission. That's about as clear a violation of copyright as you can find. Now, as you said, to the extent the street artist work isn't original, to the extent that he's copied something else and put it on the wall, then he wouldn't have an exclusive right over that. But based on the photo of the dress that you've just shown, looks pretty clear that what he's created is an original work of art, with the possible exception of the depiction of the paint can that's on there. But the rest of it's an original work of art.
That paint can. That was part of marketing.
She's just carrying it. Okay.
Yes, exactly.
So, this looks like an original work of art. It's been reproduced on the dress without his permission. I think the dress designer here is going to settle because this looks like a pretty clear violation of copyright to me. To the extent that the signature is the signature of someone who's recognized, that's a pretty clear violation of right of publicity law. So, it doesn't strike me that the dress designer has a really good case for fair use here. This is a pretty commercial use. Doesn't look like we're really creating anything new. The dress design obviously is something that the designers added, but the copyright doesn't cover the dress design. It only covers the print of the fabric that's being used in the dress design. So I don't see a persuasive defense here.
Right. Just to clarify a bit, it's hard to tell without looking at his original work side by side with the dress. But it does, in Eric Gardner's coverage here, he points out that not only is the original work included there, but also that the designer added their own painting over that of the artist, and this is actually directly from the complaint, superimposing the Moschino and Jeremy Scott brand names in spray paint style as if part of the original work. So it may be that they have some sort of thing they plan to talk about, creating a derivative work here, but I still don't think that's going to save them on a fair use argument, particularly given all you just said, Tyler. Emily, any thoughts about this?
Not really. All I could think of is what Tyler said. I agree.
Yeah. All right. Let's move on. And since we're already talking about Hollywood with Katy Perry and walking on red carpets, let's talk about a few more entertainment-related stories. All right, Tyler, you last fall wrote sort of the definitive article explaining the pre-1972 sound recording lawsuits and how they're coming into federal copyright law is coming into conflict with state copyright law, and perhaps there is not an ability to play pre-1972 music on things like Sirius XM. All of this is very convoluted and ongoing. So maybe you can first set the stage for us, tell us what's going on and who the players are, and then bring us up to speed as to current developments.
Okay, so the first thing that we need to keep straight is that when we're dealing with a song, we're always dealing with two different copyrights. One is the copyright in the musical work involved, and the other is the copyright in the sound recording. The musical work is the notes and the words in whatever form they occur, whether it be in the form of sheet music or in the form of a recording of some kind. But it's the notes and the words, and the musical work copyright is owned initially by the composer and the lyricist, the person who created those notes and words, and is typically assigned to a music publisher. The sound recording copyright covers a particular recorded performance of that musical work. So if you have a recording of that musical work, the performers and the sound engineers get a copyright in their recorded performance of that work, and that's typically owned by a record label under a work-for-hire agreement. But you can have multiple sound recordings of the same musical work, and each of those sound recordings is a derivative work. Each of those sound recordings has its own copyright. But when we're dealing with a song, we're dealing with musical works and sound recordings, and they're treated separately under federal copyright law. Musical works have been copyrightable since 1831, so there's no issue. The composer and their lyricist, the music publisher, they get paid royalties when a song is played, when any recording of that song is played, in whatever form it occurs. When it comes to sound recordings, things are a little different. Sound recordings weren't copyrightable under the 1909 Copyright Act. They weren't considered a separate thing that was subject to to its own copyright. They weren't added to the Federal Copyright Act until February 15th, 1972. Beginning on February 15th, 1972, all new recordings are subject to a federal copyright, and state law concerning that is preempted. Federal Copyright Act is exclusive. State copyright laws are preempted, which is why that preemption issue comes up in the art reproduction, in the art resale case we talked about.
Right.
But federal law expressly says we're not going to preempt state law with regard to sound recordings that were recorded before February 15th, 1972. Since we only added them beginning February 15th, 1972, it's going to be prospective only. We're not saying anything about those old recordings. We're going to leave that to state law. And so the issue here is, what rights does a record company and the performer have in sound recordings that were recorded prior to February 15th, 1972? And for a long time, it was considered that the rights they had was the right to prevent reproduction of the sound recording, the right to prevent sale of reproductions of the sound recording. So the exclusive rights of reproduction and distribution. But there wasn't any public performance right. And now we have a series of lawsuits claiming that there is a public performance right under state law for pre-1972 sound recordings, so that when those sound recordings are played on the radio, not only do they have to pay royalties to the composer and lyricist, which they do under federal law, but they also have to pay royalties to the record label. Well, that would be a pretty strange outcome, because for post-1972 sound recordings, they don't have to pay royalties to the record label when they play a recording on traditional AM/FM radio. They don't have to pay royalties to the record label if they play it on television. And that's been true since the history of radio and television. And I'll go back and talk about that history in a little bit. But then Congress changed the law in 1995. And what they said in 1995 is, if you're playing a sound recording by means of digital audio transmission, then you are going to have to pay royalties to the record label. Traditional broadcasters, FCC licensed broadcasters, they don't have to pay royalties. They're exempt. But digital competitors to those traditional broadcasters, like Sirius XM radio, like internet streaming, like Pandora, they have to pay royalties to record labels, in addition to paying royalties to composers and lyricists and music publishers. So for post-1972 sound recordings, Sirius and Pandora, they have to pay twice. They have to pay composers and lyricists the traditional ASCAP royalties, which everyone has to pay, but they also have to pay the record label something. It's a compulsory license, so the record label can't veto it, but they do have to pay some royalties to the record labels. And so the owners of copyright in pre-1972 sound recordings said, well, if Sirius has got to pay record labels for post-72 sound recordings, they ought to have to pay record labels for pre-72 sound recordings at all. Also. And federal law says, well, we're not saying anything about pre-72 sound recordings. That's up to state law. And so you had this band, the Turtles, that made these sound recordings in the 1960s. Their most famous hit is Happy Together. And they own the copyrights in their recordings to those pre-1972 recordings under state law. And they've said, well, we think there's a public performance right under state law. And we think when Sirius plays those recordings, they ought to have to pay us as well. Problem is, if we accept that theory, it's not only Sirius that's going to have to pay, it's traditional AM/FM radio it's going to have to pay, it's television stations that are going to have to pay. They don't owe any sound recording royalties under federal law, and so this whole area has gotten really badly mixed up over the question of whether there's a public performance right in pre-1972 sound recordings under state law.
Very good. Excellent overview of the situation. So now we have the Turtles lawsuit that is going forward. Plus, the RIAA has just reached a $210 million settlement with Sirius XM. How do those two play together?
So there are 3 lawsuits by the Turtles. Their corporation is called Flo and Eddie. They filed 3 different lawsuits in 3 different states, in California, New York, and Florida, because this issue is governed by state law. And so in theory, it could be different from state to state. So they filed 3 different lawsuits in federal court in California, in New York, and in Florida. And in California and New York, you had the federal district court saying, yes, we think there is a public performance right under state law. And that's the first time that that's happened in the history of radio for 75 years. So that was a really, really big deal. In the Florida case, you had the district judge saying, no, I think that would be making new law. There's nothing in Florida that recognizes any sort of right. So they turned down the right in Florida. So you've got split decisions. You had trial court victories in New York and California. They lost in Florida. After they won those cases at the trial court level in New York and California, then the big record labels filed follow-on lawsuits, also in New York and California, saying, well, if Flo and Eddie's going to get paid, obviously we need to get paid because we own a whole lot more valuable sound recordings than just the very few that are owned by Flo and Eddie. They filed those follow-on lawsuits. Flo and Eddie tried to get the California case certified as a class action. So it would cover all owners of all sound recordings. They were successful in getting that case certified as a class action. And then you had the big record labels settling for whatever the figure was. I think you said $210 million. So now Sirius and the big record labels have gotten together and say, okay, we're going to pay you $210 million for the fact that we've been paying these old sound recordings, and we're going to have a royalty deal going forward. So that suggests that Sirius thinks they had a decent chance of losing one or more of these lawsuits. We'd much rather settle with the big record labels, pay them something. Since we have to pay them for these post-72 sound recordings anyway, we'll pay them for the pre-72 sound recordings at all. We'll be fine from these big record labels. And Flo and Eddie is upset because they said, no, 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 no. We're representing all sound recording copyright owners in this class action. It's improper for the big record labels to go behind our backs and settle their case when we had our case certified as a class action before that happened. And the district judge in that case so far has said, no, I'm not going to enjoin them from going ahead with the settlement. They can go ahead and settle their case because typically in a class action, a person who has a right in a class action would have the ability to opt out from the class action anyway. So that settlement goes forward. The California case has been stayed while a companion case filed by a different plaintiff has been fast-tracked for appeal in the U.S. Court of Appeals for the Ninth Circuit. And so the briefs in that case are going to be due in a few months, and there'll be an appeal in the Ninth Circuit on that issue. In the meantime, in the New York case, the trial court said you should be able to take an immediate appeal to the U.S. Court of Appeals for the Second Circuit. The appellant has already filed their briefs in the Second Circuit. And just this week, I, along with 18 other copyright law professors, we filed an amicus brief in the Second Circuit saying, historically, there hasn't been any public performance right under state law in the state of New York since a decision in 1940, and we don't think you should change that decision now. So you've got appeals both in the Second Circuit and the Ninth Circuit that could reach 2 different outcomes because it's not a matter of federal law. It's a matter of state law. And indeed, the federal courts in those cases might decide to ask the state court to rule on what state law is. So they could actually certify questions to the California Supreme Court, to the New York Court of Appeals, which is the highest court in New York, respectively. And we could end up having different outcomes. Now, that's a problem for SiriusXM because they're a satellite broadcaster, and they broadcast the same program to the entire nation. And so what happens if you got New York saying you can't play certain sound recordings, but you've got Florida saying it's okay to play those sound recordings in Florida, but you're a satellite broadcaster that broadcasts nationwide. And so again, you have this potential dormant commerce clause issue as to whether or not New York is trying to regulate what happens outside the borders of New York, because you can't limit broadcast to the borders of New York. You can limit sales within New York, which is why reproduction and distribution rights aren't problematic on a state level. Indeed, the U.S. Supreme Court said that was okay, that states could regulate reproduction and distribution. They said that back in 1973. But when you're trying to regulate broadcasting, it seems to me that you have a potential problem of state law trying to regulate what happens beyond state borders. And so regardless of what state law says, they might decide to strike the state law down on those grounds.
Thank you so much, Tyler. This is such a morass, and it's difficult to understand, but it's a very important issue, and it could result in a good deal of music not being played because of the royalties that would have to go along with making that decision. So it'll be very interesting to see what happens in New York, what happens in California. Do you care to hazard any guesses as to where this is going?
California has a statute that covers pre-1972 sound recordings. It's been amended a couple of times. If you go back and look at the history of the statute, I don't think it's a persuasive case that it included public performance rights. New York's a little different. Some of the law in New York, there was this old 1940 case that said, well, we're not going to decide whether you have public performance rights. We'll assume you have a public performance right under state law, but we think you lost that right when you started selling records to the public. And the problem with that old case is there's some other New York cases that say, well, we don't think you lose your rights when you sell recordings to the public as far as reproduction and distribution rights go. So it's not clear how that holding applies when you have public performance rights under state law. Should you lose those when you sell recordings to the public? It's not clear how that's going to be resolved. I'm more persuaded by the fact that regardless of what you think state law does or doesn't provide, you can't allow a state to regulate broadcasting because broadcasting can't be limited to the borders of the state except for very tiny low-power stations. And certainly not when you have internet broadcasters, when you have satellite broadcasters. It's not realistic to say, well, they can only broadcast certain songs in certain states and not in others. You really need a national law here. And the Register of Copyrights has recommended to Congress that they federalize this whole area, that they make pre-1972 sound recordings covered by federal law rather than by state law. That makes a lot of sense to me, but it requires Congress to act. And we know that Congress is acting only very slowly these days when it acts at all.
Right. And it sounds like Congress made the wrong choice in deciding that they weren't going to make it retroactively preemptive. They were trying to be deferential there, but it has resulted in this whole morass.
Yes, I think in retrospect you could say that was a mistake in 1972.
Yeah.
They could just have federalized the whole area back in 1972, and at least we wouldn't have the problem of the disparate treatment of, sound recordings before that date and sound recordings after that date. And again, the key date there is February 15th, 1972. That's just when the federal law went into effect. And there's really no magic about it. There's no compelling reason why we should treat pre-72 sound recordings different from those recorded afterwards.
Right. Emily, any thoughts on this before we move on?
No, I think Tyler's done a wonderful job of explaining an extremely complex case. As you said, it is really morass, and it really does kind of harken back to the California resale royalty discussion we had earlier, but on steroids.
Yeah.
It shows you not only how difficult it is for the law to keep up with technology, but also how difficult it is for the law to resolve issues between state and federal law. But now, because the Copyright Act has been revised so many times, because copyrights last so long, we have these additional, probably unnecessary issues of going back and trying to figure out what happened when, and it's a huge headache.
Yeah, and this arbitrary date, as Tyler points out, that has no other significance other than the fact that a law happened to go into effect on February 15th, 1972. All right, let's make 21572 our second MCLE passphrase for this episode of This Week in Law. If you are listening to the show for continuing legal or other professional education credit, we have some information for you about why or how or assistance if you're a lawyer in figuring out in your jurisdiction what may be required. That's at wiki.twit.tv. find our This Week in Law page there. And we've got a nice state-by-state breakdown of MCLE requirements and who you would submit to and what forms might be involved. And let's thank our second sponsor for this episode of This Week in Law before we move into a patent discussion next. And just like our first sponsor and just like so many of our sponsors on the TWiL network, I'm so thrilled that so many of our sponsors are things that make your life useful and easier, and really just are utility things that are going to improve the quality of what you do. FreshBooks is just such a product. It's amazing how many lawyers I know who spend way too much time worrying about the paperwork aspect of their practice rather than practicing law. They've got piles of affidavits and case files that they have to manage. There are billable hours that always need tracking, expenses to manage, and client invoices to prepare and send. And oftentimes people try and do this, especially if you're like me and you have a small or a solo law practice. You really have to figure out a way to streamline that process, or you wound up spending so much time on the accounting and paperwork aspects of things and not on your actual client's needs. FreshBooks is exactly what you need to solve that problem. I use FreshBooks to manage my accounting and billing, and it's wonderful because not only is it very accessible and easy on your desktop. You'd be surprised how many people try and cobble together invoices out of Excel or a Google spreadsheet. Not only does that not look professional, but you might not, as a lawyer, very well know what you're doing. You know, the last thing you need is to get your spreadsheet set up wrong and not get the math right and then send it off to a client. You're never going to have that kind of problem with FreshBooks. It is a super simple cloud accounting software. It gives thousands of lawyers like you, if you're a lawyer, the tools to save time billing and get paid faster. It also lets you create and send invoices that are both online, so it's very easy to manage your database of invoices, and they're very, very professional. It's not something you just slapped together. You can make sure that you're keeping on track of payments. You're reminding clients when they need a little tickler. You can actually automate that process. You can automate the process of routine tasks that come up over and over again every month. You don't need to do a hand invoice or hand enter time that is something you do for every client routinely. That's just going to go in automatically once you set that up. Also helps you organize receipts. It helps you when you're on the go. There's an app that helps you manage your time if you don't happen to be at your desktop computer. You can do it from your mobile device. You can snap pictures of receipts that need to go on a bill, and they'll just go right in there for you. If you do have questions, the award-winning FreshBooks support team Rockstars are waiting. There's a real live person on the other end of the phone who's going to answer exactly what you need. Getting started is simple, and it's totally free for 30 days with no obligation. Go to freshbooks.com/TWiL, and don't forget to enter TWiL, T-W-I-L, when they ask how you heard about us. Start your 30-day free trial today. Thank you so much, FreshBooks, for making things easy and seamless in my own law practice, and for your support of this episode of This Week in Law. All right, let's move on. We were already talking about copywriting patents. Let's talk about what you can patent. Emily, patentability has been a huge issue in recent litigation and legislation. Copyright and patent reform have been much on legislators' minds, and patentability seems to be this issue that just won't go away. What is and is not subject to being patented? We've got some new guidance and interim guidance on patent subject matter eligibility from the USPTO. Maybe that's a good place to start. Can you explain to us what clarity, if any, the USPTO has shed on this issue?
To be honest, I don't know that the USPTO can provide much clarity. Typically what they do with these guidelines is they summarize some of the most recent case law and base their guidance fairly literally on that case law. So there's not really an overarching theme or an overarching picture, or even kind of an overarching explanation of how to decide whether or not your particular invention's patentable subject matter. All we know is if your invention's similar enough to these previously addressed types of subject matter, it may or may not be patentable under current case law. And I think this is part of the problem with patentable subject matter in Section 101 of Title US 35 of the U.S. Code, is that we really don't have an overarching idea of what it is we're trying to do with patentable subject matter. I think the USPTO is constantly racing to try to keep up with the latest court decisions. And the latest court decisions don't really give us an idea of what's going on with patentable subject matter and what it is we're really trying to do with it. So a lot of it is just kind of feeling around in the dark, unfortunately.
Well, you've written a very interesting article on what constitutes technology for purposes of deciding whether something is patentable. Is this something that the USPTO has taken on and tried to provide some guidance on, or maybe you can provide us with some guidance on it right now?
To be honest, I think the USPTO is probably avoiding trying to define technology. There's no kind of essentialism or some sort of consensus definition of what is technology. And even the word technology is somewhat controversial. The reason I use that term is because there have been a number of cases in which the courts have looked at the Constitution. Of course, Article 1, Section 8 of the Constitution says that Congress may provide what is effectively patent rights in order to promote the progress of useful arts. And so even though a lot of people think useful arts refers to copyright, it actually refers to patent law. And so the question is, what is a useful art? We usually translate that as technology. Again, these cases repeatedly translate useful arts as technology. But then what promotes the progress of useful arts? And those are perhaps unanswerable questions. And so a lot of the time, I think what the courts are trying to do is just trying to use their intuitions as to what does or does not qualify as technology, what does not qualify as patentable subject matter. And almost losing track of this concept of what should or shouldn't be patentable in terms of what is or is not going to promote the progress of useful arts. I think that's in there somewhere in the background, but that's a really difficult thing to predict. So I think that a lot of time gets lost in the discussion as well.
All right. Can you tell us anything, as you know, bearing in mind that many of our listeners are not lawyers, or if they are lawyers, they're not patent lawyers. Can you sort of give us the lay of the land right now on the issue of patentability and how inventors and lawyers who practice in that area can submit applications with any kind of certainty that what they're applying for is actually within the subject matter that's patentable?
So there's some areas that are clearly patentable subject matter. You invent a new machine or a new medication or a new method of making something or accomplishing some sort of function. Those tend to be fairly clearly patentable subject matter, and that's fairly clearly what we think of when we think of technology. There are some hot button areas, though, business methods being one of the most hot button, but also computer software, diagnostic methods, and then also genes and other things that are arguably products of nature or are products of biological research. And so these hot button areas have presented a lot of the difficulties that we see with Section 101, and these are some of the areas where we've seen the Supreme Court in the last 5 years take up this question over and over and over again. And the reason that these areas, even though they're clearly scientific with perhaps the exception of business methods, the question arises nonetheless about whether or not they're technology, because they don't necessarily do technological things. They're not these little gadgets. They're not these little machines that anybody would look at and say, oh yeah, that's obviously technological. That's obviously an invention. That should be therefore patentable subject matter. So for example, there was a case in which in Myriad, but the Supreme Court recently decided, this was not actually before the Supreme Court, but part of the issue that the Federal Circuit decided was whether or not a method of comparing known mutations in someone's genes with a patient's genes and diagnosing them with an increased likelihood of a certain type of cancer, whether that diagnostic method can be patentable technology. That's clearly scientific, but the question is it just knowledge? Is that something that doctors automatically do in their heads and therefore is not really an invention? Or is it something that's a naturally occurring correlation and therefore not an invention? It's just that we've discovered this extremely important fact about nature, but it is still a fact of nature. And so it's these kind of questions that really present a lot of difficulty, because we obviously want to incentivize people to continue doing genetic research and continue identifying genes that might predispose you to certain types of cancers or other diseases. The question is patent law the right way to do it? Which is more of a policy question, but under the very, very brief wording of Section 101, how do we at this moment decide whether or not that's patentable subject matter? And so it's these kinds of questions that really come down to questions of how many angels can dance on the head of a pin, is what I tell my students, because they're so difficult to answer under Section 101 of the Patent Act.
Another question that's difficult to answer, but you take a swing at it in any event, is why we have not seen the field of nanotechnology explode in the way that maybe 20 or 30 years ago people speculated that it would. And some of this may have to do with the patent situation and the patentability of nanotechnology. But you think that patenting nanotechnologies may not be crucial. In fact, you've written that it's irrelevant. Why is that?
Well, again, we think of patents as a way to promote the progress of technology. But so much of what we do in technology is what's called basic research. And we see this both in biotechnology and nanotechnology and other fields that some of the economists call science-based technologies, that basically you have to do a whole lot of basic research just to understand what's going on in nature before we can start taking that knowledge and applying it in ways that are useful, in ways that are inventive, in ways that might be patentable. But there's a concern, nonetheless, that because of the cyclicity of patentable subject matter, among other things in patent law, that a lot of this early basic research has nonetheless been patented, and in particular that it's been patented despite the fact that a lot of it's government-funded research done through universities. So one of the concerns is that perhaps we're not seeing as much nanotechnology. We're not seeing the Star Trek world of 7 of 9 and all the problems being solved by the end of the episode with nanobots, because patents are actually stultifying progress in technology rather than promoting it. And basically that there's so many patent rights that it's really difficult to coordinate them in a way that allows you to move forward and actually create patentable applications, patentable inventions from that research. But the argument is that with science-based technologies, they're difficult. They require a lot of understanding, a lot of basic research. And even once you understand what's going on, even if you've done that basic research, that doesn't necessarily mean that it's going to be immediately apparent how to apply that basic research in some sort of practical way. And so a lot of these science-based technologies, like in biology, biotech, nanotechnology, and some others, have just very, very long development cycles. It takes a long time to understand what's going on. It takes a long time to acquire the fluency in the field. And then it takes a long time to develop practical applications. And in the meantime, a lot of the investors who might otherwise help you produce these practical applications are a little uncertain because they themselves don't understand the technology and don't understand and cannot predict, in fact, what the market for those technologies might be like. So there are all these other factors, other than patents, that may be hindering development in nanotechnology and some of these other science-based technologies, and that this undue focus on patents may not be our best way of addressing what's taking so long in some of these technologies.
Tyler, do you agree there should be some sort of freeze or prohibition on patenting early stage research and science-based steps in the development of things like nanotechnology?
Well, we do have a principle in patent law that says you can't patent basic ideas, laws of nature. So, Einstein discovers E = mc squared. That's not patentable. Specific applications of that to do certain things, like create an atom bomb, that could be patentable. But the basic law of nature, the basic principle isn't. So we have embedded in patent law this notion that certain basic ideas, abstract ideas, aren't patentable. Only applications of those ideas are patentable. The problem is drawing that line. Where do you draw that line? And the Supreme Court isn't giving us a lot of guidance because 4 times in the last decade, they've looked at something and said, well, we think this isn't patentable. But we're waiting for that case where the current court looks at something and says, well, we think this is patentable. Because if you have examples on either side of the line, it gives you some idea where the line might be drawn. But right now, all the examples we have are examples of things the Supreme Court says isn't patentable. And we really have no idea where that line is going to be drawn, at least as far as the Supreme Court is concerned. I do think certain types of basic research shouldn't be patentable. But again, the difficulty is, where do you draw that line, and are you going to get enough investment in basic research if you say the results of that research aren't patentable? And those are very difficult questions.
So let's shift gears here a bit, still within the realm of talking about patents, but outside of patentability and into some specific patents that have been issued. And the conflict here between the ability to patent something and other policy interests that might come into play. Here, perhaps privacy. Much in the news this week is a patent that Facebook has gotten it's supposed to help filter spam emails. But the hot button issue about it is that it enables lenders potentially to check out the credit rating of your Facebook friends and then make decisions about your own credit worthiness based on who you're hanging out with online. So that's one that I wanted to highlight. And another is not so much about lending, but about advertising. And Apple, in this case, is either has patented or is seeking to patent. I'm not quite sure where we are. I think this is just an application to patent a technology that would enable advertisers to check your bank balance or have somehow knowledge of your bank balance and then target ads on you, whether, after they've made the decision whether you're a Walmart type customer or, say, a Gilt type customer. So I'm wondering about the collision between these technologies and privacy considerations. And also, one of our listeners who highlighted the Apple patent for me is curious about whether some of this patenting might be done defensively, that there's no actual intention to develop this kind of technology, but that a company might get a controversial patent like this to basically prevent it from being put in use. Do you have any thoughts on any of that, Emily?
Yeah, it's interesting. Kind of as a basic matter, some of these more controversial patents that are controversial not just because of their subject matter, but also because of the dangers that they might pose, raise not only issues of subject matter eligibility under Section 101 of the Patent Act, but also questions of what we used to call beneficial utility, also under Section 101 and Section 112 of the Patent Act. And generally, the courts have taken the approach that the Patent Act is not the way to address these dangers. That if we have an invention that threatens personal privacy or threatens physical harm or threatens some other sort of harm, patent law is not the way to address those. We don't decide whether it's patentable subject matter or whether it's adequately useful to be patentable based on the morality or perceived safety issues around an invention. So even though I think the average person might be somewhat alarmed that Apple is now patenting technology that would allow Apple to look at your bank accounts. It's not really, to my mind, a patent issue, and probably would not be to a court either. The question of whether or not these kinds of patentees might be doing so in a defensive posture is an interesting one. Normally, when we talk about defensive patenting, we're talking about companies patenting technology in order to create a field of safety around themselves, to give themselves freedom to operate in a certain area without having to worry about their competitors suing them for patent infringement. We don't normally think of defensive patenting as a way to keep others from practicing an invention that we think is dangerous or immoral in some sense. It's not really like, or at least we have not yet seen, a movement similar to what we see with the copyleft movement or the open source movement, which really are kind of objections to the idea of intellectual property over certain types of content. And in patent law, we always say it's a negative right. It's your right to exclude. It's your right to keep others from making, using, selling, or offering to sell your invention, but it does not give you in any way a positive right to make, use, or sell, or offer to sell your own invention. So if your invention violates some other law, privacy laws or some other law, then you may never be able to practice your invention. And so I think the courts generally look at this as a non-patent issue, and that there are other areas, consumer protection laws, environmental protection laws, state laws, that are much more effective in protecting against some of the dangers that some of these inventions pose.
All right, Tyler, you want to weigh in on this at all?
So one thing that strikes me about the Apple patent is, we're offended by the notion that an advertiser might check our bank balance before we go and buy something. And yet, what's going to happen in practice, assuming Apple decides they want to commercialize this, they want to get into this area, what's going to happen in practice is they're going to add something to their terms and conditions that says we're giving them permission to check our bank balance. And if you agree to use this product, you check the box that says I agree, and you'll be agreeing to something that you haven't actually read that says it's okay for advertisers to go and check our bank balance. We waive our privacy, our personal privacy, all the time. Big companies are collecting data about us all the time because they're hiding it in these terms and conditions that we reflexively check on without reading. And you see courts enforcing those terms and conditions, even though realistically we know that people don't read them. And so, if it ever comes to litigation, Apple's going to say, look, we put it in the terms and conditions there. You gave us permission to go and check our bank balance before we did something. And there's not going to be much we can do about it. And it's not going to have anything to do with patent law or even privacy law. It's just going to say, it's just going to be contract law. You said we could do this, and we're going to go ahead and do it.
And at 40 plus pages long and counting, I can't imagine that a whole lot of people are reading through or paying too much attention to Apple's privacy policy now or in the future, assuming it gets granted this patent. Excellent point. All right, I think we're going to go ahead and give you our tip and resource of the week. Our tip of the week, maybe, Emily, you can help explicate this one a little bit. It's a fairly straightforward tip, and it applies if you are in the UK and you've been hearing about something called unitary patents, and you might have heard that they were going to be a fraction of the cost and they were going to make your life easy. Apparently, no, that's not the case. They're going to cost the same, and they're really not going to make your life free of any more headaches than it already has now. There's a good post, sort of tongue-in-cheek exchange. Client walks into a patent attorney's office scenario written up at the IP Cat, which you can check out for yourself, that highlights this issue. And I'm wondering, Emily, if you got the chance to take a look at this, or you have any other thoughts about unitary patents that you can add to our tip of the week, other than don't think they're going to save you a lot of money.
Yeah, I have to admit, I haven't looked specifically at this particular unitary patent package. We've floated this idea around quite a bit. the Patent Cooperation Treaty kind of addresses some of this also, but the idea is that can't we streamline a lot of these patent applications? Patents, of course, are very territorial rights, and so therefore, if you want patent protection in a global economy, you have to apply for patents in every country. And it's an expensive proposition because it is the one intellectual property right where you do have to go through a fairly lengthy examination process and a fairly technical examination process. And that, of course, can be quite expensive. So isn't there a way we can streamline this? So we've done a little bit of streamlining where I know in the EU you can get your patent application kind of preliminarily reviewed and some of the relevant prior art looked at to measure whether or not this is a patent that can in fact issue, and that these recommendations can be shared with various national patent offices. And even though we've really done a lot to harmonize various intellectual property rights, including patent law across the many countries who are signatories to the TRIPS agreement and are members of the WTO, patents continue to be ultimately very territorial rights, very nationally government-based rights. And so I think there's a lot of resistance to having some sort of unified, unitary patent system. Plus, we have issues like patentable subject matter. So you get a patent. Is it patentable subject matter in the United States, or is it patentable subject matter in the EU, which has slightly different attitudes toward biologically based inventions, especially those involving stem cells or other parts of the human organism? And what would be obvious perhaps to researchers in one country may not thought to be obvious to researchers in another country. And so I think it would be difficult, even if we had a unitary patent system, really to know how to address them and how to enforce them. So what would happen if you had one country that decided to invalidate one or more claims of a patent and another country that said, no, all these patent claims look perfectly as far as we know, valid and therefore enforceable. And so I think it's going to be a long time before we can come close to anything like a unitary patent system.
All right. And if you want to check out the IPCAT post that plays out some of the, tries to bust through some of what the author thinks are misconceptions about the unitary patent package. You can find it and links to everything we have discussed today at TagPacker. You're going to go to tagpacker.com/user/thisweekinlaw, and you will find everything that we discussed on the show today. Moving on to our resource of the week. This is fun. Over in the UK, once again, that's where the IPCAT blog is based. The British Library has released over 1 million public domain images. They are available for your viewing pleasure and use on Flickr. So head on over there and check them out. There's a great post by Mark Frauenfelder at Boing Boing, highlighting some of them. So over 1 million public domain images from the British Library, always a good thing. And what's been a great thing is the opportunity to chat with two such illustrious and eloquent folks today. Emily Michiko-Morris, it's been a real pleasure getting to know you and having your thoughts on all the issues that we've talked about today.
Thank you so much for having me on the show. I really enjoyed it.
And Tyler, we can't thank you enough for making the trek up to the studio and for joining us today. It's been really wonderful to chat with you.
It's been great. It's been my pleasure. Thank you.
School is starting up for both of you soon. Is there anything, Tyler, that you'd like to highlight or let people know about that's happening at Santa Clara or otherwise in the work and scholarship you're pursuing? We know you're active in the pre-1972 sound recording cases and have recently submitted an amicus brief there. Anything else that you'd like to let us know?
School starts a week from Monday. If you're interested in intellectual property, you can check out a book that I've published, Understanding Intellectual Property Law. It's now in its 3rd edition. I'm the co-author with 3 other people on that book, and I've written the copyright chapter and worked on some of the other chapters, and hopefully that contains some good explanations of some of the basics.
Wonderful. Well, you've certainly done that for us here today, and we can't thank you enough. Emily, how about with you? Anything you want to highlight going on in Indiana or elsewhere?
Well, actually, I'm very happy to say that I'm going to be a visiting professor at the Shanghai University of Political Science and Law this coming year, and actually for the next 3 years. I just received a sizable grant from the Shanghai government and also from the university to help them develop an IP center and a comparative law center, and to do a lot of fun things. So if you're interested in coming to China, if you're interested in comparative law and comparative intellectual property law, feel free to contact me. We should have some very exciting events coming up in the next 3 years, and I look forward to it.
Oh, that's wonderful news. Thanks so much for sharing that with us and for being here today. Folks, if you've joined us at 11 o'clock Pacific time, 1800 UTC, congratulations. That means you've joined us live and have watched us record the show and seen it edit-free. If you do prefer to have your consumption of this and our other Twit shows after the fact and on your own time, then head on over to twit.tv/TWiL. The whole archive of our shows is there, as well as instructions and links to help you watch the show whenever and wherever you would like. So we're thrilled, however you decide to watch the show. And between the shows, do be sure to get in touch. My co-host, Sarah Pearson, is on vacation this week and next, but she'll be back shortly. You should get in touch with either or both of us. I am Denise at twit.tv. She is Sarah P. at twit.tv. For example, listener Jonathan Arnett let us know about the Apple patent that looks at your bank balance and had that wonderful insight that perhaps that could be the kind of patent that someone might be deciding to pursue for strategic, defensive business reasons or others. So if you have thoughts and suggestions like that you want to send along to us, please do so. If email doesn't work for you, you can reach us on Twitter. Sarah is Sarah Hinch Pearson on Twitter, and I am D. Howell over there. And we also have a Facebook page and a Google Plus page for the show. So make use of those to your heart's content. Do keep us posted as to topics you think we should be covering, guests you think we should be inviting, and thoughts that occur to you about our conversations and the issues raised here on the show. And we will see you next week on This Week in Law. Thanks so much for joining us, and take care.